Hey guys, and welcome to today's video. Today, we have a sovereign citizen right to travel trial that I've been waiting to conclude so I could give it to you guys in full context. So we have 3 very special appearances to go through with one very satisfying conclusion. So let's begin.
On the record in the matter of the people of the city of Lansing versus Rambo L, file numbers 22L2761882, 881, 883. Council appearance, please.
Matt Staples on behalf of the city of Lansing.
Okay, and then Rambo L is present. Do you have an attorney, sir?
I'm here by special appearance.
Okay. Mr. Staples, my understanding is that you're moving to dismiss these.
Just the failure to display ops, Your Honor. I did check the Secretary of State. His license is valid, and he did show me that license, and that he does have it in his possession, so that the misdemeanor charge would be dismissed.
Excuse me, but did you just say that he has a valid driver's license? So basically all of his right to travel arguments are nonsensical because he agrees with the state's position that driving is not a right, but a privilege.
Okay, and there's no offer on the expired plate and the failed signal?
Not at this time, Your Honor. I believe
Okay.
Mr. L is planning on contesting those charges.
Is that correct, Mr. L?
Yes.
Okay, we'll set them for a hearing. February 14th at 9:30. Any additional matters for the record, counsel?
Nothing for the city, Your Honor.
Okay, you're all set, Mr. L. We'll see you on February 14th. Okay, is this L Rambo or Rambo L? You're muted. You have an attorney, sir?
No, I'm here by special appearance.
Okay, I'll put you in the private meeting room with the city attorney.
Your Honor, we've actually already met with Mr. Rambo L before. He was requesting a formal hearing on these 2 files.
Okay, sounds good. Formal hearings will be set for in-person appearance.
Actually, I filed a motion January 6th. Is when it went unanswered. I would like the court to dismiss this matter.
Okay, your motion to dismiss is denied.
While completely ineffective, I do love his attempt at motioning the court to dismiss his case on absolutely no grounds at all.
How many days does the prosecutor have to answer my motion for demand for motion for challenge of jurisdiction that I submitted to the clerk, and I've served everybody, all parties? How long does he have? Because that happened January 6th.
I see it's a motion to show authority.
And also a demand for dismissal, lack of jurisdiction, failure to introduce evidence of an injury in fact, challenges jurisdiction of the court to prosecute. That was filed January 6th.
We only have one motion attached to the file. I don't see the other motions that you're referencing, sir.
It's timestamped by the court. I have it right here.
I see a motion to show authority, which the court has denied. And then there was a memo that was attached. There was not any other motion. I don't read via Zoom.
Well, fortunately for you, Judge, we do. So let's take a closer look at his finger painting before he eats it for lunch. The first thing I'm noticing is that this is a notice and not a motion. A notice is exactly what it sounds like, a declaration to all parties of the trial. And in this case, it's a notice of your intention to demand a dismissal of your case based on the reasons listed on the paper. Now, where's your motion to dismiss? Because without that, you've done nothing but put the entire courtroom on notice that you have no idea what you're doing.
It's filed with the clerk. Everybody was served.
Mr. Staples, did you get a copy of the motion he's referencing?
I see a copy of the motion to show authority in our file. I don't recognize it as any sort of valid motion or pleadings, but I see a copy of it in our file.
Agreed. That's the same the court has. It's a motion to show authority. The other motions that he's referencing was not properly filed with this court or served as the court, neither the court nor Mr. Staples' office is in receipt of it. The motion to show authority was denied, is not in proportion with the Michigan court rules. It does cite, however, Luke 11:46, the King James Version, Luke 11:52, as well as some other articles and treaties.
So our living brain donor has decided that the Michigan court rules will be taking a back seat to the King James Version court rules during today's proceedings.
But nonetheless, as indicated by Mr. Staples from the Office of City Attorney, this is not a lawful or appropriately filed motion, and for that reason, it was denied before this court. But we will
Well,
set your matter.
I like to challenge jurisdiction right now. I have the right to
You can file an
travel.
appropriate motion with the court under the Michigan court rules to challenge jurisdiction. But what we won't do is entertain motions under the King James Version of the Bible, okay?
That was a different motion you're referring to. That was the motion to show authority.
We don't have the other motion, sir. So you can file that motion. It's just, we don't have it. I don't know why we only have one motion, that we don't have the other one you're referencing. So you'd have to file that and serve it on the city attorney. We'll give you time to do that. I'm gonna set both of these matters for hearing though.
I can't chill. You telling me I have the right to challenge jurisdiction right now? I want to challenge jurisdiction right now.
You can file a motion for challenging the jurisdiction, sir.
I can't do a verbal motion?
No, you cannot.
So you tell me I have a right to do a verbal motion?
You don't have a right to do that. You're gonna file it in writing and you're gonna serve it properly on the parties that you're filing it against, okay, sir? March 14th at 10:30 in person at the court will be the date for the formal hearing, and then we'll hear any arguments on motions if necessary. You have any questions today, Mr. L? Okay, well, then you're all set. Thank you.
Okay, so now we're on to our third and final appearance by First Blood L, the King James Version.
Okay, you can have a seat. Thank you. Today's the date and time set for a formal hearing. I have, I believe, one witness on Zoom. Counsel, you can proceed.
Officer Vanderwerf, would you state your name for the records,
Oh,
please?
you want to call him? Let me.
Oh, I'm sorry.
Swear, man, no worries. Vanderwerf, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Judge.
For brevity purposes, I'm not going to bore you with the prosecutor interviewing the officer that pulled over Sylvester Malone L. Bay. I'll just give you the important bits.
So I was traveling southbound on King when I observed a pickup truck in front of me that was changing lanes, failing to use its signal. So at that time, I activated my overhead lights on the vehicle to initiate a traffic stop. And then I made contact with the driver, who was later identified as a Rambo L. In our contact, he ended up handing me a piece of paper. At brief glance, when I looked at the piece of paper, it appeared to have what I believe was certain MCL codes that the subject may have typed onto the piece of paper. When I had asked him for a driver's license or identification, he was not really very cooperative. I also don't believe I was provided any insurance. At that time, I decided to issue him a citation for failing to signal, changing lanes, and failing to display a valid license, and then also the license plate through the system was expired.
Mr. L, did you want to question the witness?
Yes. The document that you were referring to, it was a travel document. I was showing you, I was traveling versus driving. And I tried to explain that to you. And then you held me on the side of the road for approximately an hour. I requested a supervisor because they might better understand what I was doing, and you never provided that for me. Is that correct?
That's actually incorrect, because the reason that you were held on the stop for as long as you were is because I was waiting for a supervisor. So when I realized the supervisor was not there, I contacted him by phone, at which time he said he was delayed. And when I came back up to the traffic stop, I did ask if you wanted to wait further for a sergeant, and I don't believe that you did. And then you drove off when you were free to go.
Yes. Is it correct that I was held on the road for approximately an hour waiting for this whole encounter to end?
I do not remember if it was an hour specifically, but I do remember that the time length was probably, I would say probably close to that at the very least.
Well, it was an hour, and it caused me to be late for my son's banquet.
So I guess it's the officer's fault that you'd rather stand your ground based on a delusional belief system rather than just follow the law and make sure that you're available for your son's banquet. And let's not forget, the officer testified that the delay was caused because you requested a supervisor. So it's your own damn fault.
And the reason, and I never got to speak to a supervisor. That's all the questions I had.
Okay, any redirects?
No redirect, Your Honor.
Okay, any additional witnesses today?
None from the city.
Okay, Mr. Earl, are you calling any witnesses today, or did you want to give your own testimony?
I would like to, I have some, I have a defense, my
Well-
motion.
Okay, well, you filed a motion?
Yeah, I filed a motion, served across the
When did
city
you file a
attorney.
motion?
It was filed, it was mailed February 18th.
You filed a motion and mailed it February 18th. Did you serve a copy?
To the clerk of the courts and also to the city attorney's office.
Did you receive any motion, sir?
Your Honor, we did receive a motion. It did not have any hearing date stated on it. We had no timetable for a response. I would be happy to respond to the motion on the record orally or provide the court with briefing if they would like.
The court didn't get a copy of the motion in February.
I sent it to the clerk. And,
Yeah, typically when that happens, it's just attached to the file. I don't have a copy of any motion.
well, I did my due diligence. I sent a copy to him. He has his.
Well, I don't know that you did your due diligence, because when you file a motion, you got to get a hearing date for that motion. And so
Who's supposed to give me a hearing? I
you
filed
got to
it
get the hearing date from the clerk's office.
from the clerk's office.
Yeah.
So why did they give me one?
Did you contact them for a hearing date?
I contacted them, yeah.
And ask for
And I
hearing
asked
dates
them,
for your
and I
motion?
asked when was my hearing. They confirmed that it was today.
For your motion.
And I asked, did I have a hearing date? And they
But-
said,
And you do have a hearing date, but that's not what I asked you. Did you ask them, did you have a hearing date for your motion?
See, this is where representing yourself can be tricky, and why I will always say it is in your best interest to hire an attorney, because the court rules and procedures are not as simple as Perry Mason makes it out to be on TV. In Michigan, you don't just file a motion, but you also file a notice of hearing, which is usually attached to the motion. Once it's been served on all the parties, you'll get a motion hearing date, and it's on that date when your motion will be heard. Now, most courts are extremely lenient when it comes to pro se litigants, and this court is no different. So they'll hear his improperly filed motion and rule on it today, but it still won't change the outcome.
for my motion,
Yes.
they didn't tell me, but I did provide to him an order for the motion that gave him 21 days to respond.
Okay, you can make your motion before the court because I don't have a copy. You can make it now orally.
Okay, well, now comes the beneficiary for Rambo L, defendant in error, here by special appearance, not submitting to the court's jurisdiction, hereby moves the court to strike and dismiss the complaint filed by the officer, Zinderbar, am I pronouncing that right? Sorry if I'm not, for lack of ratification and commencement, no corpus delicti, no plaintiff, lack of jurisdiction, personal, firm jurisdiction. Christina Simmons being appointed as trustee, the prosecutors being appointed as co-trustee, I, Rambo L, an executor and beneficiary of a set of account. Also, I filed a declaration of non-citizenship nationality because I've done a name change.
Oh my goodness, you can't be this slow. First, a name change doesn't automatically reject your citizenship. In fact, that's so wrong, it's not even wrong. Second, for you to get a name change in the state of Michigan, you have to petition the circuit courts. And guess what? The circuit courts gets its jurisdictional powers from the Michigan Supreme Court, and guess who gives the district courts its jurisdictional powers? So if your arguments are that the district courts don't have jurisdiction over you, then the circuit courts didn't have jurisdiction over you for your name change to begin with. It's a very classic case of having your crayons and eating them too.
Where my point of authorities are the United States District of Columbia Corporation in Volume 20, Corpus Juris Section 1785, we find United States government as a foreign corporations with respect to the states. Since the corporation is a fictitious person, it can't see, speak, smell, or touch itself. It's a fiction in the real world. It needs a conducting, transmitting utility, a liaison, some sort of connection to a fictional person. Constitutional Amendment number 1, Congress shall make no law respecting an establishment of a religion, prohibiting free exercise thereof, abridging freedom of speech or right of press or right of people, peaceful assemble, petition the government for redress of grievance. Number 5, Constitutional Amendment. The right of people should be secure in their person, houses, papers, in effect against unreasonable searches and seizures shall not be violated, and no warrant shall be issued upon probable cause supported by an oath or affirmation, particularly describing the place search of persons, things to be seized. And then number 7, Constitutional Amendment, suits at common law where value of controversy exceeding $20, the right of a jury trial shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States according to the rules of common law. I asked for a jury trial, I didn't get that.
Wrong again, dipshit. While Article 1, Section 14 of the Michigan Constitution does allow for jury trials in civil cases when one party properly demands it, there is no Michigan statute or court rule that guarantees a jury trial for civil infractions.
Rambo L is a man, people, but not a person. I was not operating in commerce, nor was I a driver on the road for travel. A driver is an employee transporting goods or passengers. Rambo was just merely traveling and in my private property. Here are some examples of my Supreme Court constitutional defenses. Number 1, case number 1, right to travel is part of a liberty where citizen cannot be deprived of due process under the 5th Amendment, Kent versus Duels, 357 U.S. 116, 125.
Some of you may remember from my last video that I briefly covered Kent v. Doles. This is not a driver's license case or a vehicle registration case, but a passport denial case based on political discrimination. It doesn't apply in this situation, and neither do the next handful of cases that he's about to cite. So I'll let him get all the way through his case law defense, and then I'll briefly point out why each one of them is wrong.
Case number 2, I have the right to travel freely and unencumbered pursuant to Shapiro versus Thomas, 394 U.S. P. 618. That right is so basic, it doesn't even need to be mentioned. The state of Michigan arbitrarily and erroneously perverted my right into a privilege and issue a license and a fee for it. Murdoch versus Pennsylvania, 319 U.S. 105. Supreme Court trumps everything, says that no state can convert a secured liberty into a privilege and issue a license and fee for it. Case number 4, Shuttle versus Birmingham, Alabama. It shows that I can ignore a license and engage in the right with immunity. Case number 5, Marbury versus Madison, 5 U.S. 137 shows that any law in violation of the Constitution is null and void. Case number 6, Shuttleworth versus Birmingham, 373 U.S. 262 says I may ignore the license and the fee and engage with the right with immunity. That means you can't punish me. And United States versus Bishop defines willful willfulness as an evil motive or intent to avoid a known duty, task under the law, with a morality certain. I submit I couldn't have been doing a evil task. I totally followed the Constitution in the Supreme Court. Bryers versus United States says it shows how the judge is supposed to interpret the Constitution, and it's supposed to be interpreted in the favor of me. A.M. Jurisprudence, Volume 16, Section 97 of the Constitutional Law section says it should be received as a liberal interpretation in favor of the citizen, especially true with respects to those who were designated to safeguard the liberty and security of the citizen in regards to both persons and property. See note 31, Bryers versus United States. No state may convert a liberty into a privilege. Murdoch versus Pennsylvania. An appearance ticket is not accusatory instrument. It doesn't confer jurisdiction over the defendant. People versus Gabay, 670 New York 2D 92517. I was not engaged in a commercial trade at the time of the alleged infraction, and I do not proceed to say a license is upon a constitutional detention. Motor vehicle means every description of a carrier drawn by mechanical power used in commercial purposes on a highway.
Okay, so let's start at the beginning and work our way up. First, we have Shapiro v. Thomas, which our brainless wonder got wrong because it's actually Shapiro v. Thompson. This is a case regarding the legality of residency requirements for state benefits, and not a case challenging the legality of statutory driver's license requirements. Murdoch v. Pennsylvania was a case involving the unconstitutionality of Pennsylvania forcing religiously based organizations to get a license to sell literature door to door. Again, nothing to do with driver's license. He cited both Shuttle v. Birmingham and Shuttlesworth v. Birmingham, which I believe to be an attempt at getting the same thing wrong twice, as Shuttlesworth v. Birmingham covers requiring permits and licensing for constitutionally protected civil liberties. And while your right to travel is a protected civil liberty, driving a motor vehicle is not. Marbury v. Madison states that if a law is unconstitutional, it is essentially void. And since the Constitution has something called the 10th Amendment giving states powers to govern themselves, laws requiring state driver's license are not unconstitutional. U.S. v. Bishop doesn't apply to you as you willfully violated the law, regardless of whether your intent was evil or not. There are no federal agencies involved, so Bryers v. U.S. was a pointless citation, and while yes, under 18 U.S.C., the definition of a motor vehicle reads as a mechanically drawn carriage and in commerce. You haven't provided any evidence to the court that you were engaged in commerce, so that definition of a motor vehicle does not apply to you. The definition you're actually looking for is found in MCLs 257.33 and 257.79, which define a motor vehicle as a self-propelled device used for the transportation of people or property on the highways. Nowhere in the relevant definition does it say anything about a requirement for commercial activities, so every one of your irrelevant citations is a non-starter for your defensive position, and you're an idiot.
And then there's neither injury nor any trespasses. All crimes are commercial, 27 CFR 72.11, and every alleged crime has to have a nature and cause and be prosecuted by the name of the people of the state. I don't have a contract with the state.
You already presented your driver's license to the prosecutor. So even by your own diluted view of how the judicial system works, you've already contracted with the state.
I don't see an injured party. I don't know why I'm here.
Any additional
I
argument on your motion?
would I would ask the court to dismiss this to failure to state a claim where relief can be granted.
The court has heard the argument. I'm first address your motion, Mr. L, and I'm going to deny your motion as clearly indicated in the response by the city. Your claims would be most appropriately brought before the Court of Claims, and so you can't challenge a constitutional issue in this court, okay? As it relates to the authority and the process to bring this matter before the district court as relates to your civil infractions. You have an expired plate and a failure to signal. Again, a jurisdiction or venue before this court is appropriate. This is a situation or incident that occurred in the area of South MLK, Martin Luther King Boulevard. That's in the city of Lansing, Ingham County, state of Michigan. And so you're subject to the laws and the ordinances of the city of Lansing, but also the laws under the Michigan compile laws. Here in this district court, we are subject to the Michigan court rules. And so although I gave leniency with your motion, it was not properly filed and or served. But it also does not comport with the Michigan compile laws or Michigan court rules. And so for those reasons, it is denied. Now, as to the civil infraction, failed to signal an expired plate from December 3rd, 2022, we do not provide any valid dispute or defense to these civil infractions. You could have appeared and showed information that demonstrated you did have a valid plate at the time, or that you even have one now, which could reduce the citation, but that's not taking place. And so I'm going to sustain both violations of civil infractions. There's a fine of $125 on each. Okay, sir?
My next defense, so am this done or can I say something else?
You can say something else. I asked you if you had any further defense, but you said.
My next defense would be, Michigan allows 72 hours to register any vehicle when it's first purchased. He never asked for anything. I never got a chance to explain myself on the side of the road.
Okay, do you have proof that you had just purchased it within 72 hours?
I don't have the title.
Okay, thank you, sir.
You know, we always say that arguing your case on the side of the road is not the time or place to do that, and that that's what the courts are for. And yet here you are in court arguing that you shouldn't be held responsible because at the time your car was recently purchased and fell under a 72-hour grace period, but then failed to show the court your transaction record or a bill of sale or any evidence whatsoever that validates your claim. Forgive me for saying this, but I think you're full of shit.
If the defense is not meaningful, if you can't provide any evidence to support that defense. That being said, your fine is $125 on each file. When do you intend to make payment?
Do I have a chance to appeal this?
You can.
I would like to appeal.
Okay, you want to file an appeal? It's the civil infraction?
I want to file an appeal today.
Okay, you can file a motion for reconsideration. But you need to follow Michigan court rules, okay? We don't submit to the sovereign rules, okay? You take that to the sovereign court.
I love how the judge just tells him to take it to sovereign court, which is nothing more than a daycare center for adult toddlers. Alright guys, that's the end of the video. I don't think it's a surprise to anyone that the sovereign citizen losers lose again. If you liked the video, leave a like. If you disliked it, leave a dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.